Hey, good morning, everyone, and Introduction to Law. I'm going to do a quick review, quick for me, Chapter 2, an Introduction to Law. And this is the courts. Um, Something just popped up, so I can't see myself, which is maybe a good thing. There, now I'm back. So, again, I'm trying to draw out what I think are the critical aspects of each chapter, hoping to give you maybe a little bit deeper or at least a reassuring understanding of what the chapter's important aspects are. Going through chapter 2, uh, it calls it judicial law. I don't know if I'm so comfortable with judicial law. I like to more aptly, I think, describe it as the common law and the role of the courts. And again, the common law, when you hear that term, is very broad because depending on the context you're explaining or discussing the common law, it might mean the historical principles and rules and procedures that we adopted throughout history, even throughout European history, that have become part of our own legal system. But for practical purposes, when you hear common law with paralegals and attorneys and legal scholars in the realm of actually practicing, we're talking about court made law. Decisions that have either clarified other forms of law, the Constitution, statutes, administrative rules and regulations, or when there was a valid legal controversy, I'll get to that in a second, and there's no legal standard to really be applied from one of those other bodies of law, administrative law, ordinances, statutes, Constitution, the court needs to craft a legal principle. That's called a common law. And they do it usually from the appellate court or higher. It's rare for the trial court to be thought of as an originator of law, a creator of law. So if I have a legal controversy and I have a statute that might be applicable, but the statute's kind of generic in terms of the elements that have to be established, I might want to see how the appellate courts have treated those elements in breathing life into their contextual application. Um, why the appellate courts? Because the trial courts really don't have any binding authority on future decisions. It's only the appellate courts that create precedent where stare decisis will apply, that will follow it in future cases. So I might be in the superior court or in the district court, and I might say to the judge arguing, the legal standard means this because the Massachusetts Appeals Court has said so. Or from the federal court, I might say the Circuit Court of Appeals has articulated that the application of this principle should mean X, Y, and Z. And that's the common law. And the common law is very big. In fact, I get legal questions all the time, and I look at the statute. I'm like, I don't resisting arrest says you can't resist arrest. I mean, it's pretty vague. What does resisting arrest actually mean? Do you have to throw fisticuffs? Do you have to run? Or is running away from an officer alone resisting arrest? And the case law often helps us answer those questions because through that body of law that gets developed over time, we can often find contextual relationships. This is especially true of search and seizure, for example. When is it appropriate for a police officer to search a motor vehicle without a warrant? Well, it's obviously contextually derived, and we look at history of other cases when the court will determine it's inappropriate, when the court will determine it is appropriate. So if I get a case where somebody was pulled over and saying I-290 in Worcester, and the police say because of certain factors that they witnessed or interpreted, they felt that they were justified in searching the trunk of my client's vehicle without a warrant. Now, some of you can say, well, that's illegal. You have to have a warrant. Well, you don't always have to have a warrant. And who tells us when and when not the application of a warrant's necessary and required? Case law, court decisions from the past. So if I practice a lot in an area, I might have some familiarity with the current status of the law when it comes to search and seizures of trunks of motor vehicles without a warrant. But oftentimes it's evolving and it changes based upon context. And so we need to look at court decisions. So they talk about what are the purposes of judicial law. One is to clarification of law. That's probably the biggest area or the most obvious area because courts have to tell us what the context of the law often means. Sometimes it's obvious. Going through a red light is against the law. It's pretty much straightforward. We don't need to look to case law to find its meaning. But sometimes you have to find out self-defense. My client says the reason why he struck the other individual wasn't defending himself. Defending himself from what? And then we say, well, the other person was coming at him with uh, a wiffle ball bat, plastic bat, and they were going to hit me with it, or hit my client with it. And my client, therefore, shot him. And then we have to get into the whole aspect of when is reasonable, what is self-defense, when is it reasonable, what can be used, what are the parameters, what is the imminent fear of physical harm. We look to case law. And there's a huge body of case law. And sometimes it's not always answered. When it's not answered, and the book didn't do a good job of this, sometimes a novel question will come before the court. That's called a case of first impression. We might be in the role of helping create new common law or a new standard from the appellate court or higher, meaning we'll get to that in a second, but most states in the federal government have a tripart system. We have trial courts, then we have a court of appeals, and then we have a court of last resort, or in Massachusetts called the Supreme Judicial Court, and on the federal level called the Supreme Court of the United States. Sometimes they get novel, new, unresolved questions of law, not questions of fact. Questions of fact are determined by the trial court, but legal application, what the law means, is sometimes taken up for the very first time. And that can be very exciting for lawyers that like to do appellate work, or I don't know, have an ego. I guess most lawyers do. I don't know. You want to have a case of first impression and hopefully come out the right side of the decision so you can brag even more than having an appellate court case. So that's one tier, is the clarification law, which I think is the most important for us. The other is the protection of the law. I don't even like that terminology. What I think is giving the law integrity, meaning that knowing the court system is there to enforce the law protects society. Because if we can rest assured that laws will be enforced, we can abide our conduct by it. We can play by the rules and have a peaceful, successful life and hopefully thrive. But we also know our rights and our property won't be impinged by other people who aren't obeying the law, because if they don't obey the law, we know we can seek judicial remedies to enforce it and seek money damages or to stop the individual from doing wrong to us under the law. I don't know if I really like that part of the chapter, but it's in there. Now we talk about stuff that's pretty meaty and stuff that I think we can get into pretty deep, and that's the structure of the judicial system. First, we should talk about the trial court versus the appeals court. I'll start with Massachusetts. I think we have 7 trial courts, and there might be a couple of obscure courts with specialized jurisdiction. Federal court has a similar system. What are the trial courts? Trial courts are where a case originates. Sometimes they're the court of original jurisdiction. Sometimes they're also called court of record, because that's where the evidence is introduced, and we keep a record of what factual information was produced for the judge or the jury to believe. And we'll get into it in a later chapter. When do you get a judge trial? When do you get a jury trial? Might as well segue into it right now. In the trial court, you always have a right to a jury trial, or the defendant in a criminal case always has a right to a jury trial. Doesn't mean they have to have one. They can waive. It's only the defendant makes the decision in criminal court. They can waive it to go in front of just a judge. Maybe the judge has a reputation of being exceptionally fair and reasonable. So maybe we don't want to take the risk of putting the matter in front of the citizens of a community that we know very little about. The other, maybe we think we have a very technical argument, or a case that really tugs on the emotion of the fact finder, where a judge we might think might be a little bit more disciplined and apply the law a little bit more judicially, I guess, because my client might have been really in a very bad situation that has a lot of ugliness to it, for lack of a better way of saying it, but there was no crime committed, and maybe that's better to have a judge trial. But so in criminal cases, the jury is always available, but the defendant can waive it and go in front of just a judge. Either way, the verdict is binding, provided there's been no error of law. Trial courts determine facts through the judge or the jury, depending on the kind of trial you have. In a civil case, most civil cases also provide for a jury trial, but the jury is available to both the plaintiff and the defendant. Both parties would have to waive their right to the jury trial in order to have what's called a bench trial, or trial just in front of a judge. It's a little harder to do, because to get both sides to agree is difficult, to get them to waive and go with just a judge. Now, not every civil case has a right to a jury trial. I used to do some divorce work, and every so often I get somebody goes, "Oh, I can't wait till the jury hears about my spouse being an unfit parent or squandering all of our money." And then I hit that the deer in the headlight goes off for me, and I said, "Whoa, whoa, whoa, we don't get a jury trial in the probate and family court because there is no statutory right to a jury trial or constitutional right to a jury trial in that kind of case." Same with speeding tickets. Every so often, someone will be in court and you'll see a person called very smart, educated, but not educated in the law, and they'll be up there and they'll say, "I'd like to invoke my right to a jury trial, Judge." And Judge said, "We don't get a right to a jury trial." Sometimes the judge is thrown off guard because they just don't have that happen very often. And the defendant goes, "Well, I believe this is the United States of America. I believe we believe in process, and I think I have a constitutional right to a jury trial. I'd like to invoke that right." She goes, "No, you don't have a right to a jury trial." And the person might say, "Well, why not?" And sometimes the judge gets thrown off, and in the heat of the moment, "Well, you just don't. Not this kind of case." And I remember seeing this one time happen, and a judge took a moment and says, "Because certain things in the civil realm, in a speeding ticket in Massachusetts is civil, you don't always have a right to a jury trial." That's one. Workers' compensation cases, you don't have a right to a jury trial. Most family law matters, you don't have a right to a jury trial. But most contract cases, most negligent cases, tort cases, you have a right to a jury trial. I don't know them all. Sometimes you have to do a little bit of quick research to determine whether or not a jury trial would be applicable or not. But at the trial, whether it's a judge trial, whether it's a jury trial, this is true of the state system and the federal system, facts are introduced, and it's up to the trier of fact, which is a jury, or in the case of a jury waived case, a judge. The trier of fact determines what to be believed, how much of it to be believed, and what happened factually in the story. That's usually not appealable. Questions of fact are not appealable generally. There's always some exceptions to these rules. Law always has exceptions. What does happen potentially for an appeal is a question of law. The legal standard wasn't applied appropriately. The procedures the court followed were invalid. Those are legal errors. Otherwise, every single loser in any trial would always appeal. The reality is very few cases get appealed. Very few cases get appealed successfully is because you have to allege a what? An error of law. The legal standard was not applied appropriately, or was misapplied, or was erroneously instructed to the jury. Something about the legal process was flawed, not the factual determination. I can't believe they thought I robbed that store. I want to appeal the case. A good attorney would have to counsel their client was, well, we have to find an error of law. Some of the evidence that was either allowed in or was not allowed in, or the witness testimony that was given was inappropriate or wasn't even allowed, or maybe we were looking for a continuance because we needed a witness that was out of state and we couldn't get him in until next week, and the judge wouldn't allow a delay in the trial, created an error of law. But to say that the jury came to the wrong conclusion, that my client robbed the bank, it's not appealable. The facts are set in stone. That's why if you go to the appeals court, maybe we can even do it maybe this semester, maybe future semester, I don't know. But the general rule is when we go on these field trips, we often go to the Supreme Court of Massachusetts. It sits at the John Adams Courthouse in Boston. It's a fun trip. And if you like seafood like I do, I usually like to go out to Legal Seafoods on the Back Bay afterwards and have a nice meal and talk about the appeals court we've seen. And I always get students. Some of the best students I've ever had will often go into the court. It's just beautiful. This Brazilian, I think it's mahogany, whatever, just really rich in wood and tapestries. And you feel very impressed when you go into the Supreme Judicial Court of Massachusetts. And before it starts, we get in a little bit early and we kind of look at the seating arrangements and where the judges sit up high and all that stuff. And I always get that question from my students, and say, where does the jury sit? What's the first thing I have to say? Juries determine fact. That was already concluded at the trial court, the court of original jurisdiction, the court of record. What they're going to do here is attorneys are going to argue that at that trial, there was either a legal error or there wasn't a legal error, and they'll review the transcript of what happened at the trial to determine whether there's a legal error or not. And that's the big distinction between a trial court and an appeals court. Trial courts determine factually what happened. The judge gives the jury instructions on what law applies, and they determine a verdict. Civil case is called responsible or not responsible, or liable or not liable. In a criminal case, it's guilty or not guilty. After the trial, everyone that loses usually says, I want to appeal. But again, what do you have to argue? Some legal error occurred. It's very narrow. It's very difficult. And that's why we want our government to give us good judges, because judges are the gatekeepers of evidence and procedure. So we make sure that the verdict is not necessarily correct, I mean, hopefully it's correct, but that the legal standard and the legal process was done appropriately to make sure it was fair. That's the main goal. So that's trial court versus appellate court. In Massachusetts, again, starting with our trial courts, we have the juvenile court, deals with juvenile justice, mostly juvenile delinquencies, but also something called care and protection. I don't know if they have CHINs anymore. They have something like it. Kids that are basically out of control and they need court intervention. And the crimes are basically juveniles are charged with committing a crime. They also have the right to a jury trial, right to an attorney, the same rights as everybody else. The Constitution is applicable to juveniles as well, although it tends to be closed to the public because we want to protect the juvenile's identity. Juvenile court has a different goal than the criminal adult court in that it's rehabilitation and correction as opposed to punishment and sanction. I think it's the same. But they also deal with something called care and protection. That's when a child is either being neglected or abused by their parent, and we need the state to intervene in the custodial arrangements. In the juvenile court has some other jurisdiction too. Then there's the housing court, deals with landlord-tenant questions primarily. Then we have the probate and family court, which deals with people who passed away to make sure their property is distributed appropriately and creditors are paid. The loved one gets their, the assets of the decedent, the person who died. And the other thing that obviously probate and family court sounds so nice, right? We're here to help families. It's really divorce and custody battles, but it's also adoption. Some of it's positive, I guess. And they have other things called conservatorship for people who have incapacity issues mentally, and they have to have a ward take over. I don't want to get too technical, but that's what they deal with. So that's probate and family. Land court, very obscure. And the reason why it's obscure is many of the questions that go before the land court, I think, can also be dealt with the Superior Court. I'll get to that in a second. So I hit juvenile, I hit probate and family, I hit housing, hit land. Probably missing one. The two big courts now are the District Court and the Superior Court. These courts are what we call sometimes courts of a general jurisdiction. They hear a broad array of type cases, often concurrently with other courts. So some of the things you might have been able to take the housing court, you might be able to take the district or superior court because they have concurrent jurisdiction. Like restraining orders can often be heard in multiple courts, including the district, superior, and family court, for example. Domestic relations restraining orders, that is. Those are two big trial courts in Massachusetts, the district court and superior court. And the difference is almost implicit. The district court hears criminal matters that usually are of a certain severity criminally, and same with civilly. There's of a certain presumed value. If you want to know the rule, basically, district court can keep jurisdiction of cases where the penalty won't be more than 2.5 years in the House of Correction. If it's a felony and there's a potential for a state prison sentence of a year or more, that's what defines a felony, usually the Superior Court has jurisdiction. And sometimes I've heard it called a wobbler, not math, I've heard other people call it wobbler, but basically there's sometimes concurrent jurisdiction. If the government decides to prosecute in the district court, it'll be a felony still, but it's going to be resolved in a district court knowing the maximum sentence is 2.5 years in the House of Correction. Doesn't mean it's not a felony. District court can hear certain felonies. But the Superior Court obviously hears more serious felonies and hears more significant contractual and personal injury cases and things of that nature. By its very nature, it has that title. Again, there's often concurrent jurisdiction between the courts over certain questions. Trial. Facts are determined, laws applied, verdict are happened. Appeals court. Someone's alleging an alleged violation of a legal standard. Those are the basic trial courts in Massachusetts. I don't think I missed any of them. I practice mostly in the Superior District Court doing criminal defense now. I hope I never do another divorce. I hope I never do another housing matter because those are the worst, evictions and things. I think they're the worst. Occasionally do juvenile court cases because there's a criminal aspect to it. And I don't know why I decided to specialize in what's left of my career because I teach full time, but I just find it a little bit, the window of a case has very clear definitions, unlike a divorce, which will last forever. In housing court, I just find it very, very challenging emotionally, so I stay away from that stuff. So that's our trial court system. In our appeals court, we literally call the appeals court Massachusetts for Massachusetts questions, state questions, is called the appeals court. It's very simple. And then the highest court in Massachusetts, dealing with the Massachusetts Constitution, the Massachusetts Appellate Court, and believe it or not, this is going to confuse a lot of people. The state courts can often hear many federal questions unless the federal system has determined to have exclusive jurisdiction in that question. So I can raise a Fourth Amendment under the United States Constitution in the state court system, but the federal court will have final say on whether or not that interpretation by the state court is correct or not. Don't worry about that too much. For the most part, state courts handle state law questions, and the federal court definitely only hears federal questions. So what's the federal system set up as? Well, there's at least one, there's multiple trial courts, courts of original jurisdiction, but the main one's called the Federal District Court. There's courts of international trade, there's courts of tax, there's courts of U.S. claims where you're suing the federal government. Those are specialized courts in the federal system. They're much more narrow. But every state has a court of with a general broad jurisdiction on federal questions. And federal questions aren't that many. It's why we only have usually for example, Massachusetts only has 3 federal district courts. One sits in Springfield, one sits in Worcester, and one sits in Boston to hear federal questions. Now, can you ever bring a state court claim in a federal court? Yeah, I'll bring it up in a later chapter, but that's called diversity jurisdiction. That's when the plaintiff lives in one state and the defendant lives in another, and the claim's worth more than $75,000. Our forefathers thought that one party would have an implicit form of favoritism by being from a certain state, whichever state that the claim is brought in is the home state of either defendant or plaintiff. It would create an unfair playing ground, and the federal court would somehow be, more neutral. The party should be able to bring their litigation to the federal court, even though it's a state court question. It's called diversity jurisdiction. We'll get to that in another chapter. The federal court has an appeals system, and it's called the Circuit Court of Appeals. Once you hear circuit, you know you're in the federal system, or at least not in the Massachusetts state system. There are 13, really 11 circuit courts. Then I think DC has a specialized one, and there's another one that's specialized. But here's what's interesting. We live in the First Circuit Court of Appeals, Massachusetts, and there's a chart in your book. I can't remember which states are with us. Find the map. Yeah, we're with Maine, New Hampshire, and Mass. And I believe Puerto Rico is with us as well. The Second Circuit is Vermont, New York. The Third Circuit is Pennsylvania and the Virgin Islands. Fourth Circuit's pretty large. It is Virginia, West Virginia, North Carolina, South Carolina. The 11th Circuit, Alabama. I'm not going to read them all to you, but you get it. It's kind of regionally set up. What's interesting about that is the First Circuit may have a legal question before it. They come to an answer that creates common law, and that's the new legal standard under the federal statute or constitution or regulation. But the Ninth Circuit out in the West Coast might have the same legal question come before them. They're not bound by what the First Circuit says. Now we've got this dichotomy of justice where in the First Circuit it means, one, that was over gay marriage for a little while, until that's when the Supreme Court will often want to hear the question to resolve a debate under the federal law, what the standard applies, because we have inconsistent justice in the federal system depending on what circuit you're in. And that's kind of important. Like, think about it. If I'm in the Massachusetts District Court tomorrow, which I will be for a trial, I'm going to have to cite Massachusetts cases. It doesn't mean no good if I have a great Connecticut case. It might if there's no previous history in Massachusetts on the question. Say our sister state, who we have a very similar statute or principle with, and we believe that there's a strong rationale to follow what they've done in Connecticut. I ask that you adopt this legal reasoning from the state of Connecticut on this legal question. Well, the judge is going to look at me and say, well, there's no Massachusetts appeal. What if there is? I'll look like an idiot because they'll say, well, Massachusetts is where we are at, and we're going to follow the Massachusetts Appeals Court or Supreme Court of Massachusetts. But sometimes we cite out-of-state and out-of-jurisdiction cases when there's a vacuum in the law. It just hasn't been decided yet. That's true of the federal system. We might not have resolved that in the First Circuit. The Ninth Circuit maybe in a way that I like or my client likes. I might say, well, the judge in the Ninth Circuit has had this very question before them, or a very similar question with very similar facts, and they came to a very just conclusion that it should be this. So I want you to follow the Ninth Circuit. doesn't always work. It's not binding upon the First Circuit. It's called persuasive authority, and it's also sometimes called, although it's primary law, it's primary persuasive, not primary mandatory. We'll get to that in a later chapter. So now let me just go back to my outline that's in the beginning of the chapter. So that's the federal system in terms of the Circuit Court of Appeals. And then there's the United States Supreme Court. There's a few cases. Most of the jurisdiction of the United States Supreme Court is appellate. They only hear a few cases of original jurisdiction. I think it's lawsuits over treaties and certain lawsuits over certain ambassadors and public officials. They could claim from one state against another, goes right to the Supreme Court for a trial directly. Very rare. Most of the Supreme Courts is appellate. Now, in order to get to the Supreme Court, some appeals are allowed to go there. I mean, if you appeal to the Supreme Court on certain questions, there's statutory authority that they must hear it. Rare, very narrow. Most of the Supreme Court decisions, or decision to hear the case, is just that, a decision. You do what's called a petition for certiorari. Don't ask me how to spell it. It's in your book. It's CERTORII, something. I tailed off there because I can't remember how to spell it, but it's pronounced certiorari. You do a petition for certiorari saying we have a very important federal question. We think the Supreme Court needs to resolve this for the basically for the quieting of the legal question for the entire nation. So it's often constitutional questions that get up there. And the Supreme Court determines whether they hear the case or not. It's mostly discretionary. And how does it get determined? Well, there's usually 9 members of the Supreme Court. Why do I say usually 9? Well, sometimes one croaks and dies midterm, and it takes a little time to replace them, or one abruptly retires because of who knows what issue, and there might be a gap. Or on some questions, certain members of the Supreme Court might recuse themselves, not want to hear it because they've worked with one of the litigants before. But it's called the Rule of 4. When 4 members of the Supreme Court say, we want to hear this important federal controversy to quiet a question under the Constitution or under a statute, if 4 members want, that doesn't mean they're going to rule in your favor, by the way. They just want to hear it. You know, I know people that get excited and goes, I've got certiorari. It's called a petition for certiorari, and then they decide to take the case. It's a writ of certiorari, agreement to take the case. They get all excited. The Supreme Court says they're going to hear my case. That doesn't mean they're going to rule in your favor. They might slam you and come down on the other side of the decision. But the Supreme Court, we know, is the final arbiter on what the federal Constitution means. It's a very big deal. That's how a case gets to the United States Supreme Court. If you're really interested in if you follow the news at all, you know that it's a very it's the least politicized branch of government. There's no question it's politicized, because when a Supreme Court vacancy occurs, it's the President of the United States, who we live in a very divided country right now, and whether you like the current president or hate the current president, it's the president that gets to pick the next candidate to be Supreme Court, but it's with the approval of the Senate, which might be at odds. And they sometimes don't want certain people in certain philosophical outlooks, because they know that person will have, with 8 other people, 9 in total, will tell us what the supreme document of this land means, the Constitution. Critical. And it's clearly partially political. So that's how they get to the different. In the state, Massachusetts is somewhat similar. It's not a writ of certiorari, but you petition the Massachusetts Supreme Court. You always have a right to appeal, unless you can cite an error of law. You're going to win to the circuit, to the Court of Appeals. But to get to the Massachusetts Supreme Court, you file a petition and appeal to it, and sometimes they have to hear certain kinds of cases. Like first degree murder, they always have to hear that. In fact, you can't even not hear. They always review them on their own accord. They want to make sure there's fair play in these decisions that deprive people of their liberty for the rest of their lives. Now, the next question is, well, how do we analyze law? And this is a question I remember my dad. I bring this up in my video all the time. I was thinking about my father. I remember I was in law school, and he said, what are you going over today in law school? I said, legal analysis. My father was pretty witty, and he was a plumber. He wasn't educated in college or anything like that. Didn't mean he wasn't smart. He goes, well, what is legal analysis, Jim? And I say, yeah, it's analyzing the law. And he goes, I bet there's a better definition out there. And so if you watch this video, you say, what's the one thing I got out of Corman's video today? Legal analysis means applying a legal standard to a factual, contextual situation. That's all. And we do it all the time. Lawyers do it, paralegals do it, citizens do it. You get charged with something, or someone's telling you have to do something or can't do something in your business or whatever it is. You find that legal standard. And most legal standards have elements. A, B, C, and D have to exist before this law is applicable. And if it is applicable, then you have to do certain things or not do something, do certain things. And then we take the facts of the situation. We derived facts to either equal or mirror the elements of that statute and say, yes, that statute does apply, and therefore you have, or you could challenge the statute saying it's unconstitutional, but generally speaking, that's legal analysis, applying factual elements to the law. And what's the little acronym we use in the book? Does a pretty good job. I wish they had it out in bold. It's called IRAC. IRAC is issue, rule, analysis, and conclusion. That's a real shorthand version. So if you ever panic on a test, ever in life, IRAC's a nice template. An essay question. Well, let me identify the issue. Let me talk about the rule or the legal standard that applies. Let me apply that, which is the analysis part. Let me apply the legal rule or standard to the facts that we have, and then I'll draw a reasonable conclusion. It's writing an essay for any kind of legal problem. So sometimes, when I'm in front of a jury and I'll think, what do I want to tell this jury at the end of the day? I want to do a little legal analysis with them in a persuasive fashion, of course. But, I want to say, the issue before you is this. The legal standard that we have that you'll be applying based upon what the judge will instruct you, I believe is this. And the facts that we have here either do or do not equate to a violation of that law. That's the conclusion, because you do some analysis with it. And that's what we do. We break it down into parts. Now, sometimes with a statute's real easy. OUI. Well, I should say none of it's easy for the most part because they're nuanced. I'll give you a violation of a restraining order, domestic relations restraining order. First, that there had to be a valid restraining order. It had to be in existence at the time because they expire and they start at a certain time. It had to be served upon the defendant, meaning the defendant had to be aware, either constructively or actually. Constructively means it was served on them. They didn't necessarily read it, but they should have known what its contents were. And then third, they failed to comply with the terms of the restraining order against them. And then we'll get into, okay, well, that seems pretty straightforward, right? Well, that's statutory analysis, right? Because that's the statute, the restraining order statute requires that. And they'll be punished up to 2.5 years for violation of that restraining order. Well, what if my client has a restraining order and it says stay 100 yards away from Jane Doe? And my client, Sam Adams, was walking down the street because they live in the same town, and he was across the street. The person who had the restraining order was very upset, thought he came within 150 feet, and my client never saw the other party. And the other party even says, I don't think Sam Adams even saw me. He was walking on the west side of the street. I was on the east side, but boy, I saw him, and he was within 100 feet. Did he violate the restraining order? Some of you would jump right and goes, yeah, he's not supposed to be within 150 feet. He was within 100 feet, so he violated the restraining order. But then the question I would ask as a defense attorney is, well, does he have to have knowledge? Does he have to knowingly violate the terms of the restraining order? Statute doesn't say so. I'm not saying that's necessarily true. I'm just giving you a hypothetical. So we would do what? This is where we go to case law. And I would have to look at case law to determine whether or not the Court of Appeals or higher, the Supreme Court of Massachusetts, has interpreted the elements of a violation of restraining order to require scienter or knowledge. And then how much knowledge? Like, what if my client looked over at her and waved? Well, then we don't have an issue of interpretation anymore. We don't have to do legal analysis. It's obvious he saw her. He called her name too. Let's assume he's not waving at the person. There's no other person on the street, just Jane Doe. My client goes, hey, Jane, sorry we didn't work things out. Nice to see you. And he's clearly, we measure, and I've done that before, we actually measured because some people say he was within 50 feet. It turns out he was 200 feet or whatever. So actually, I had to bring a town engineer in the case to show the difference between where she said he was and where she was to prove it was beyond the 100 yards or whatever it was. But there we don't need to do a lot of judicial analysis. We don't have to do case law. What is case law analysis? We have to look for a case that has significantly similar facts, critical facts, key facts, not surrounding contextual facts, but facts that relate to the law we're trying to apply. And the law question, the legal question, has to be identical. And that's called being a case on point. If you have a case on point and it's from our jurisdiction, similar facts, same legal question, that applies as precedent. And then we can argue to the court. If I was the prosecutor, judge, the statute does not require, and here we know because of this case that from 3 years ago from the Massachusetts Supreme Court, says the defendant simply has strict liability, regardless of knowledge, of knowing that the holder of the restraining order was in the area. If they violate it within 100 yards, it's a violation. No knowledge is required. I'm not saying that's what the case law says. I'm just giving you an example. Strict liability. And, and I would probably know that same case. We'd probably try to resolve the case because my client would be in fact guilty if that's what the law required. That's called case analysis. Case law analysis is pretty hard because when you read a case, they're often 20 pages long, and there's a lot of contextual facts, and there might be multiple legal questions being resolved in that case. And you're trying to figure out, does that case from 3 or 4 years ago from the Supreme Court of Massachusetts bear on mine? Sometimes they're almost identical. When they're almost identical, you're going to say, that case is on all fours with my case. All 4 corners of the page, it's almost identical. That means the case has very strong precedential value for your outcome in your case. And that's what we do as paralegals and attorneys. We try to find applicable law that clearly answers our legal question. And sometimes you'll hear attorneys, I hope I don't do it. I think I have a lot of integrity. And I'm not saying attorneys don't have integrity when they do this. They'll sometimes bring up a case that just doesn't have enough similarity in the factual question that is derived, or the legal standard is totally unrelated. Like somebody bringing up a case goes, that case deals with the search of a home. I'm dealing with the search of a person's body cavity. I think they're very different standards, Your Honor. And the prosecutors citing that case is a red herring. It's inapplicable. It's not precedent for this question. And that's the debate we get into sometimes. So you're trying to look for the case that's most closely related factually with the same legal question in order to help the court interpret where the law and how the law should be applied in that circumstances. So I kind of like I call it FIRACSI. That's my own little thing. I always want the facts first. And what facts do I want? I want a little context so the court and the listener can understand what, cap and fact. You got to give people like a setting of the story. But then in the legal issue has 3 main components, and the book doesn't do a great job of this. And this is not a legal research course, but you should always know that when you frame a legal issue, you want these 3 legal components. And that is the key facts, meaning those facts that have either were changed or left out would change the outcome of the case. Key facts plus a question with regard to the legal standard. So facts, question, legal standard, all in one statement. So under the restraining law, or the key facts would be, when the defendant is within 100 feet of a victim of or the holder of a restraining order, when the prohibition is within 100 feet, and they are unaware, that's the question, of the petitioner's whereabouts when a valid restraining order is held against them. That's the legal standard, the valid restraining order. So it takes time to develop legal questions, issue statements like that. And it's hard work, but so we give some facts, some key facts, but some contextual facts too, so the reader understands it when we do our legal analysis on paper, if you will. We frame the legal issue. We give the law, whether it's sometimes it's both statutory law, then a couple of cases right there, eliciting what the actual law should be in that contextual situation. And then we do our analysis and we draw our conclusion. And that's what we do in the court all the time. I just give you an example why it's so important to do statutory analysis. Maybe I should tell the story because people think, I had a guy that was charging lewd and lascivious conduct, okay? I took for granted what the elements of that statute was. I just think, if someone gave me the facts of my case that I have with this client, if it were true, I say, yeah, that's lewd and lascivious conduct, because I just use the terms like in a kind of like a informal fashion. I think I know lewd and lascivious behavior when I see it. Well, I'm not the law. In preparing for the trial, thank goodness I prepared, Although my client denied any of the conduct happened, that's not the important part. The important part is I'm preparing. That's how I started preparing my theory of the case. This just never happened. This is a vindictive person. They're lying to try to get my client in trouble because they had a housing relationship and they were trying to get each other evicted, blah, 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 blah. Well, I'm doing the elements of the case, and I look up the elements of lewd and lascivious conduct. I'm trying to do good yeoman service as an attorney. This is 25 years ago. And I didn't know it, but one of the elements of lewd and lascivious conduct, I'm not going to get into the other nasty 3 or 4 first elements, but the last one is it has to be in a public place. Well, my client allegedly did this in the privacy of their apartment. So I'm not saying if he did those things, he denied it, but if he did those things, he might have done other wrongful things, but it's not lewd and lascivious conduct because it required that final element of being in a public place. Your privacy of your home is not a public place. So my point is the discipline of finding out what the law or the rule requires in terms of all of its elements are very important. Like I do a lot of OUI practice, and I can remember when I was first operating under the influence of intoxicating liquors, I remember I had this case, and thank God it jumped out at me, but it didn't jump out at me the first second. I had these kids, young people that had a big 4x4 lift vehicle, like shocks and stuff that lifted the vehicle really high, and they're drinking and partying on something called the power lines in the rural area where it goes through the woods, and there's like, I guess, construction vehicles that go fix the power lines or check on them and keep the vegetation down so it doesn't affect the electrical wires. Have to be able to drive through the area. So these kids do it too, and they go out and they drink and they party in these, in the woods, and they access it through the power lines. Well, cops came because somebody saw it or heard it. Neighbors that weren't too far away. They come out. My client's driving his 4x4 Blazer thing. He gets stopped and he's pretty well intoxicated. So, boy, you get charged with OUI. And right away I said, geez, I'm looking at the video. There was a breath test. I said, it really smashed. Your Blazer's a vehicle. Okay, it was running. You're operating it. You admitted you were driving it. And then all of a sudden it dawned on me, well, it has to be in a public way or a way in which the public has a right to drive as invitees. He was trespassing. So all they could get him with was trespassing. I got the case basically dismissed because one of the elements were missing. So that's real important. We have to be disciplined, not to be overly cocky like sometimes I think I can be, or confident that I think I know what things mean just because I exist. You have to really know, and sometimes when you read a statute, you read the elements, and then you don't always know really what they mean in context. You have to look at case law. Now, the good news, those of you that are a little intimidated by the law, maybe you're new at it, you want to become an attorney, you want to become a paralegal, you're like, I don't know anything about the law. Well, neither do any of us. But you're going to develop the ability to find the law and answer legal questions when they come in. So to this day, because I practice in a certain way, I look at people ask me questions about patent law and copyright and stuff I don't really practice. And I say, I don't know. And they'll say, well, what kind of law school do you go to? Are you still concussed from that car accident and you don't know anything? I just don't practice. But could I find the answer if I had the time and the patience and discipline to look into it? Sure. You guys will too. So if you feel like you don't know anything of the law, you're in the right place. Over time, you develop a certain niche of information if you want to work in a narrow area of law. But if you want to work in a broad area of law, be comfortable with not always knowing the answer to everything. Be unafraid to say, I don't know right now. It's going to take some research to find all the answers before things happen. And also, I'm a little impatient. I was interviewing a client yesterday, and she was giving me unbelievable factual information from every part of her life over the past decades, and my head was spinning. I think her head was spinning, and I really needed to take all that information because you think you know what the elements involved in a case are, and you're trying to reel your energy into getting facts that relate to those elements, which is important. But don't be afraid to get the whole story, because later you might find when you look at the elements, information that you might not thought of as initially important might bear on one of those elements. So you got to be a patient investigator to get all the facts that are important, because if you don't have the facts, you might be buried. And this video way too long, but just a quick story. I didn't have it, but a friend of mine had it. I always love the story where a woman's filing a restraining order. She comes into the law office. She has two black eyes, and she tells a story that my husband punched me in the face last night. I want a divorce. I want to get custody of the kids. I want to get a restraining order against them. And the law firm is outraged. Absolutely. This poor woman's been battered, and they file a restraining order. And the attorney said, "Do you know if your husband has a lawyer?" The lawyer's my friend. And he goes, "Yeah." So they serve the lawyer that they're giving a notice for all these emergency orders to get custody, to get the house, to get charges against the client. And the attorneys know each other. So the other attorney, the one that's representing the husband, gets all this notice, and he calls up the other person and says, "Hey, Fred, what are you doing? Did you see my client, two black eyes?" "So you see my client?" He goes, "No." "Did you read the paper?" He goes, "No." He's in intensive care. They're looking for your client right now. There's charges of attempted murder against her. He's been stabbed several times by her. And the reason why she's got the two black eyes was he was able to fend her off enough to get out of the house and collapse on the neighbor's front lawn before getting the EMTs out there to save his life, because he almost bled out." And he goes, "Your client, the wife, was trying to murder my client. And the only reason she has black eyes is because as she was chasing him out of the house, she tripped on the stairs and hit her thing on the railing, and it was witnessed by everyone. And then she fled the scene." There's a little exaggeration in the story, but I want to give you. So the thing is, until you know all the facts, don't always jump to the conclusions, because we all have these inherent biases and things like that when we think about facts. And I tend to be an impatient interviewer of people. I don't really like to talk to people a very long period of time. Apparently to myself I do, because it's almost an hour I've been talking to the video here. But if it were one-on-one, I'd have you in my office, because I'm comfortable and I like to cut to the chase with things. But I think chapter 2 is good about the courts. And if you want to do a field trip, we should talk about it. I know it's an online course. You don't have to participate in these things, but I teach some classes related to history and law in on campus, and this might be a good time to go up to the John Adams Courthouse and watch the Supreme Court. I think the Supreme Court in action is fun. You can also, I know Mark Goldstein is the presiding judge in Gardner, and he just sent down an invite to me. He teaches for our program too, by the way. You might have him as a professor if you're in the legal studies program. I don't know what he has, real estate or maybe the legal studies seminar this semester, maybe litigation, I don't know. But he's invited us to come out on a Friday. Fridays I usually free, to come out and watch some trials or motions in front of him, and you can talk about the role of the courts and things like that. And sometimes seeing it and experience it breathes more life into this dryness of this text. Otherwise, don't be afraid to reach out with questions, concerns, issues, comments, whatever. Otherwise, be well, and chapter 3 will be up hopefully before you get to chapter 3. Take care.